702.
World of Work. In today's fast-paced and hyper-connected world, the line between personal choices and professional consequences is thinner than ever. Of course, I was speaking now about astronomer. Until very recently, we had no idea what astronomer was, but it was an international scandal involving the CEO and head of human resources at the tech company. It sparked a global debate about leadership, about ethics, and about accountability. While the incident unfolded thousands of kilometers away from us, it also raised questions locally about our workplaces and the impact of personal actions even outside of the company and whether or not those would matter. That's the conversation we are having at this moment. I'm joined now on the line by Ryan Anderson, who's a labor law executive at LabourNet. Ryan, good morning. Thank you for joining us.
Hi, good morning, Tshidi. Thanks for the invitation and honored and privileged to be a part of your show.
Thank you so much. So let's look at what is legally expected and what South Africa's laws say as far as this issue is concerned. What qualifies as misconduct? By definition, misconduct in the workplace, what does the law say here?
So in the very general sense, misconduct is any behavior or conduct from an employee that breaches a workplace rule, standard or legal obligation. So it's essentially employees putting a foot wrong in the workplace. These rules would either be formulated in a written document, such as an employment contract or company policy, disciplinary code, or they could be implied and tacitly accepted as the commonly accepted way of doing things or required standard of behavior in an employment space.
And these carry more weight the more senior you are. So if you're a senior executive, a CEO, what are the implications or expectations on people who carry higher office in the workplace?
For sure, and absolutely. And I think the case that you mentioned in your introduction has just shone the light on how significant and how much higher the stakes are when CEOs misbehave themselves. CEOs are essentially the face of the company. They're meant to set the tone for culture and ethics. So when they misconduct themselves, there's a little bit more on the line.
Definitely. I mean, I still can't get over that particular issue. I remember having a debate in our own newsroom about why would a CEO need to step aside, step down in a situation like that. And for me, I kept thinking about the morality clause, and that morality clause issue I took from, I think, a movie somewhere, but I'm sure you're going to shed more light on what that is. But in terms of the Labor Relations Act itself and the guidance it provides, you said that you could be in a written contract. How does it guide companies in terms of dealing with misconduct? What is stated there that must be considered for senior management?
Well, a movie is an interesting reference point, but fortunately we have got legislation in place that regulates and provides more sophisticated frameworks for us to follow. So the Code of Good Practice in the Labour Relations Act clearly details misconduct and processes that companies need to follow when employees misconduct themselves. In this particular case, it was a very interesting one because you've got the office romance on the one side and the rights of an individual to integrity and privacy. But as soon as this starts to impact on the workplace, you've also got to look at the prerogative of a company to manage risk and to maintain professionalism. And the fact that we in South Africa are still talking about this global incident just again reiterates the impact and the significance of what something like this can do to the reputation of a company.
In my defense, Ryan, about the movie reference, I'm not the expert. You are. That's why you're here to help us out. The issue of procedural and substantive fairness, that's also something that you kind of hear about these processes. When action is to be taken, maybe let's take a step back. Determining the action that is to be taken, what considerations are taken then in light of the contract that the CEO would have signed, in light of the company's own disciplinary code of conduct?
Yeah, let's maybe use this case as an example. Although it happened in America, we'll apply it to South African legislation. So the first step would have been to decide whether or not the CEO had actually broken a rule. So for it to be quantified and defined as misconduct, there would have to have actually been a breach of some form of workplace rule or legal obligation that the CEO misstepped. So the first point of call would be to assess whether this had actually been contractually agreed to or regulated through some or other company policy. And if that was the case, a company would be able to take action against the individual. But even if it wasn't put in any written document, there is still a fiduciary duty on an employee and specifically a CEO of a company to act in the best interest of the company and to refrain from any actions or conduct that may cast the company's name in a negative light. And practically, I believe he's a married man, and the other individual involved also married. And practically, the implications of engaging in that sort of behavior. Unfortunately, he was caught in the jumbotron. But even just going out in a public space and engaging in an affair as the face of the company and putting a company at that sort of risk could be seen as a breach in that fiduciary duty.
Isn't that where that idea of a morality clause also comes from, where CEOs are expected to behave in a particular manner? The more senior you are, you're expected to behave in a particular manner because, as you said earlier, these are the faces of the organizations.
100%, and there's a responsibility on a CEO to set the tone for the company, the ethical tone, set the culture, live up to those standards, and there's a lot of individuals following them. So, 100%, that morality and breaching that is definitely it hinges on the trust relationship with the individual.
And then looking at the South African example again, Ryan, what are the board's options on the table when they are confronted by a situation like that, where a CEO's personal behaviors damage the company's reputation? What considerations would they have? What options do they have on the table?
Well, look, let's put it within the South African context. So they would, as much as we've agreed that the conduct is untoward and there's consensus on the fact that the CEO had misconducted himself, within the South African context, he would still be entitled to the rights afforded to him in the Labour Relations Act. And that means that he would be entitled to a fair disciplinary process, be entitled to have the opportunity to present a case and to defend himself through a formal disciplinary inquiry. So those processes would need to unfold. I know in this particular instance, the CEO decided to step down. And in many cases, these high-profile cases do result in a resignation or some form of a mutual separation. But if they can't reach an agreement on that, yes, a company or a board would subject the CEO or the individual to a formal disciplinary hearing, which could result in a dismissal.
Earlier, I think I had touched on it, and I think in a way you've kind of described it, because the process in and of itself, that's where the idea of procedural and substantive fairness will come into play, is how they handle the matter if it does go to a disciplinary hearing.
Yeah, 100%. And I think from a procedural point of view, to maybe break down the steps and processes that would unfold, is the board would most likely suspend the individual due to it being so high profile and the imminent risk that an individual like that might present to the company staying in this sitting role as CEO. The company would put a formal notice to attend a disciplinary hearing in place with charges. In this case, the charges would probably relate to bringing the company's name into disrepute, conduct untoward, and talking to the reputational damage that the company can face as a result of this. And then, as I said, a formal disciplinary inquiry where parties would be given a fair opportunity to present their case.
Remember, guys, if you've got questions for Ryan around misconduct, if you've seen it playing itself out in your workplace, got questions, you're curious about it, you can call in. The number to call in is 011-883-0702, 072-702-1702. Have you ever had misconduct involving a senior manager in your workplace? If you are in management, how do you handle misconduct within your ranks? What are the things that you've done in order to manage that kind of behavior and to address it efficiently? Please feel free to call in and to weigh in on the conversation. Ryan, earlier on you mentioned the Jumbotron. Obviously, he was caught at a Coldplay concert. We are in a digital era. The minute you step outside of your homes, you're pretty much at risk of going viral. In a situation like this, how have companies prepared themselves to also manage the reputational risks that come with the digital era? What can they do? And even, I suppose, for the employees themselves, if you may, what do you then do? Because you have very little control in the digital era, I think, in terms of what of you gets taken, in this case, the Jumbotron as well, and goes viral.
Yeah, 100%. I think the name of the game is regulation and enforcing policies to create awareness around expected and required standards of behavior. So in this particular case, an off-duty conduct policy would have been relevant. I think also regulating, being very specific on this example, really regulating office romances. So in anticipation of a question along these lines, I pulled up some statistics around workplace romance. And it turns out up to 60% of people confirm that they have been involved in some form of a workplace romance. And around 43% of people meet their spouse or partner in a work-related environment. So I think the key thing here is that there's nothing inherently wrong or romance, office romance in itself is not inherently misconduct. But when it starts to impact the company or the workplace, it becomes a problem. And that's where that balance that I spoke of comes into play, where there's a right to the individual and the employee to their integrity and privacy, but also a company's ability to manage risk and professionalism. So it's all about policy, creating awareness and trying to regulate it as much as you can so that we all are playing by the same rules and are informed of what those rules are.
That's a very interesting part, and I'm glad you brought this as well, because so many people do meet their partners in the workplace. We're in conversation with Ryan Anderson, who's a labor law executive at LabourNet. We're discussing the issue of misconduct in the workplace. How do companies manage this? What are your experiences? Feel free to call us as well. Have you seen misconduct taking place at your workplace and looked at how your company addressed the scandal? Have you ever been involved? Are you a manager who's also trying to manage the issue of misconduct? If you've got questions, we've got a guest on the line who can help you with that. We'll also love to hear your stories as well. But let's take a quick break.
702 World of Work.
It's 11:24. You listen to the World of Work feature. We're in conversation with Ryan Anderson, who's a labor law executive at LabourNet. We're discussing misconduct in the workplace. I did say you can call in, put questions to our guest. Ryan, I've got a couple of questions for you. We'll go to Busi in Ekurhuleni. Good morning, Busi. You want to speak to Ryan?
Yes, morning. We have an issue at work where there's a policy that says lending and borrowing of money in the workplace, it's not allowed. But then it seems most of the employees were not aware of it, and they've been borrowing and lending each other money. But the policy refers for self-enrichment. But these employees have been borrowing each other money and paying the money back. Will that be also regarded as a misconduct? Because the culture allows it and it's been happening, but apparently they were not aware of it.
All right. Thank you so much, Busi Nekurhuleni. Thank you. Ryan, I mean, that's an interesting question because it sounds to me that people are helping each other out financially, borrowing and loaning each other money. However, there is a policy in place. The culture's developed, but there's a policy. How should companies navigate that?
Good morning, Busi, and thank you for the question. So I think it comes down to why the policy was put in place in the first place. So my assumption would be that it's the borrowing and lending of money amongst employees has in some shape or form started to interrupt or affected the workplace in some way. And that's why the company decided to put that in place to regulate it. A company wouldn't be able to just put rules in place and arbitrarily enforce certain standards. They've got to be reasonable and valid. So I think the core of your question would come down to that is why was this enforced in the first place? Were there some issues? Were there some problems that between employees that were maybe spilling over into the work environment and creating a disharmonious environment? Busi, maybe I'm going to throw the ball back in your court and ask whether that is the case.
She's dropped the line, Ryan. She's kind of left us. She just left you with that question.
She dropped off.
Yeah.
Well, then I'll leave my response open-ended. So essentially it comes around companies have got the right to enforce workplace practices and policies which will lead to good governance and a harmonious work environment. And as long as they're not arbitrary, as long as they're reasonable and valid, they are within their rights to do so.
On the WhatsApp line, a message for you. Do all employees have a fiduciary duty? I thought this applied to board members and senior executive employees only.
So that fiduciary duty to act in the best interest of your employer would be implied across the board. It would be with any employee. As soon as there's an employment relationship and there's that connection and nexus, there's a duty on both parties to act in the best interest. But it would be even more so the more senior you are in the business, and especially in this case where it's the CEO and they're the face of the business. And that's the difference between an employment relationship and a regular contract or independent contract engagement, is that there is actually a stronger connection between parties and more obligations.
The importance of a clear code of conduct, Ryan, stating exactly where the company stands on managing particular situations, on prevention, really, in some cases. I mean, the issue of office romance, in essence, we see a lot of companies attempting to manage that by not wanting office romance to happen. How important is it for companies to put together a very clear code of conduct?
So important, TB. In fact, as LabourNet, our first point of call with any of our clients is to initiate a labor audit up front and to implement regulatory policies to govern, or first and foremost, a disciplinary code which sets about the rules of engagement, and then policies which will further regulate specific areas of the business where we feel additional protection is needed. And it's very, very important. We want to create awareness around what the accepted standards are. Your previous caller alluded to the cultural element of lending and borrowing money, and we must acknowledge that we operate in a diverse environment in South Africa with people from all walks of life, and it's important that as a company we clearly communicate what standard is required and what the particular rules of engagement are.
As we wrap up now, Ryan, the lessons South African companies must draw from some of the high-profile cases we've seen around the world over the years. What are the important things that South African companies should learn, of course, in accordance with what our legislation is on the issue of misconduct and what the labor law dictates?
Yeah, I think it's how to mitigate risk as far as possible. We don't want to have an overly rigid and unnecessarily strict environment, but we do want to do a proper stock take of where our risks lie and what measures we can put in place to mitigate. And in these particular instances, to set clear standards and codes of conduct on what accepted forms of behavior are. You alluded to it in one of your previous comments. We operate in a digital world where something can go viral within seconds, and all of a sudden everybody knows who the company astronomer is. And I don't think it wasn't really a household name before. So there's a lot at stake, and we need to be careful that we put whatever measures we can in place to mitigate and to ensure that our company and the brand reputation is looked after.
All right, thank you so much. That's Ron Anderson, a labor law executive at LabourNet, speaking to us there about the issue of handling misconduct in the workplace. It is 11:30.